Estate disputes and prenuptial agreements. Closing arguments.
I have the honor and privilege of representing and making closing argument on behalf of my client, the Schmearman.
The Schmearman.
Your Honor has heard the evidence. I will not bother wasting your time or anyone else's time. The case is compelling. My client is here seeking your order to set aside the marriage contract that was entered into less than 120 minutes prior to the marriage on September 4th, 2009. Of course, I don't think that it's a matter of controversy as a matter of law that in the event that this court finds that the marriage contract was in fact invalid, for grounds which I will address, he may be permitted to file an election under the Family Law Act for equalization of net family property. However, even if the agreement is found by Your Honor to be valid, there are two statutory provisions which permit this court and authorize this court to award him support under the provisions of the Succession Law Reform Act. And as I'll make clear in my brief submissions, Your Honor, the key time to be looking at the snapshot of the circumstances is the date of the hearing today, June of 2016, and not on the date when the parties entered into this contract, even assuming that the circumstances, the unusual circumstances, I would submit, of how the parties entered into this contract. I'm not going to focus much time on the law of donatio mortis causa for a variety of reasons, but I will make reference to the late Yenta's dying words in the course of my submissions and submit what reasonable inference this court might take from those words. I wanted to say also that I've learned a great deal about this case after the brief was prepared in hearing the evidence as it came out. Your Honor has been doing this for some time and recognizes that we never know exactly what evidence is actually going to come out, even where we have transcripts of prior examinations for discovery. The Court of Appeal, which I need not remind Your Honor is binding, has stated very clearly that a marriage contract is a device by which a party can opt out of most or part of the provisions of the Family Law Act, namely its property provisions, its support provisions, but fundamental to a choice by the Schmearman to opt out of the legislative scheme is a clear understanding of what one's rights and obligations are and what they might be if there was no marriage contract. And it's in this context that the Court of Appeal has indicated that financial disclosure is critical. And Justice Mesber, in the Patrick decision, made it clear that what parties are not allowed to contract out of is their obligation to make disclosure. And in terms of the circumstances that you have heard, the most entertaining evidence, particularly from the deceased's son, Erwin, is the fact that the disclosure made by Yenta in the marriage contract, with the advice of her certified specialist legal advisor, was so woefully inadequate that in my submission it would be unconscionable for this court to say that appropriate disclosure was made. The suggestion that the applicant, poor twitching Mr. Schmear, was sufficient so as to entitle him to have a clear understanding of exactly what rights he was giving up by entering into this contract is, in my submission, inconceivable. There is authority that is cited in the factum that has been filed, and I know that you've carefully read it and carefully read the authorities that I've referred to. This court has previously set aside a marriage contract when the husband provided an accurate list of his assets but failed to provide a value for those assets. In this case, I would submit that an even stronger argument would be made in that no list of assets was provided and no values were provided.
And if I agree with the evidence of Mr. Schmutta that Richard was aware of the nature of assets and the general values, is that not enough for me to find that he was generally? I think the case law, the Ludmer case, talks about general awareness. I mean, certainly we don't have to have a valuation on each asset, do we?
I agree with you, Your Honor. And certainly we've come front and center and cited even the authority, as you mentioned, in the Ludmer decision, where I think it was Justice Penny accepted that a general awareness of the assets was sufficient. There's no question that Mr. Schmier could have done a better job in terms of following up afterwards. This was maybe described by Irwin as a shotgun marriage, but the marriage which he conceded, and it likely was probably the only objective piece of information that that witness conceded without bias, was this 5-year marriage was a good one. Not that whether it's a good or bad marriage is a relevant factor, but I do note that he was quick to rush to other judgments on his interpretation of the facts, but conceded that the marriage was a good one. So it wasn't a shotgun relationship. Fortunately, my client's wife didn't pass away immediately after the ceremony. In any event, the suggestion that my client had an opportunity in terms of the disclosure that he might have been aware of, which is a matter of, really it's your role to decide whether or not you accept the evidence or not. Please keep in mind the opinions of Drs. Verschlepte and Dr. Crank. My understanding is there was no evidence called in rebuttal, but as I say, the facts.
We had to get this trial going and over because of the golf game, so yeah, there are problems with some of the evidence.
So the only evidence I think that's before the court, which is unchallenged, are the 2 medical opinions that suggest that my client's capacity, not the capacity to manage his own affairs, but his level of concentration, the diagnosis that he had, which apparently was in existence, if I understood the facts correctly, at the time of the marriage, might have compromised his ability to fully appreciate the nature and consequences of what he was giving up when he signed the agreement.
Can I just ask you, Mr. Rabinowitz, about the reference of stone? I don't want to rush you, but are you going to talk about that? I'm interested to hear your comments on whether stone applies to a potential dependent support claim.
Yes, Your Honor, I'm happy to go there without...
Or you can go in whatever order. It's just something I'd hope you... I was
going to touch on, Your Honor. I'm in your hands as to whether or not I do it right at the moment. I was always told, don't delay and don't avoid answering the question.
In this case, you can.
Thank you. In any event, they knew each other. This is my client and Yenta for approximately 2 months prior to their marriage. While they had a general awareness, perhaps, of each other's assets, they both spent the same amount of money. There is no question that our client made full and frank disclosure as required under the statute. And therefore, Yenta, who was described by Irwin as being meticulous, walking around with a calculator, all about security, all about safety, even while having a cardiac arrest, was providing the details of the access code to the safe in the cabin. So this meticulous business lady, it was all about the schmatas, she knew that spending the burn rate that they were living under during the course of their marriage would have exhausted his resources. Not that that's determinative of what this court should do, but I think it's a reasonable inference that this sophisticated business lady would have appreciated that he would be left with Zippo if this burn rate would have continued. Not that she was planning to die on the day she died. This was apparently a sudden tragic event on the second cruise, I guess. In any event, I would submit that the unconscionability arises from the inequality of bargaining position. Irwin, experienced matrimonial litigator, conceded that he drafted this agreement without instructions from his mother. In other words, it sprung upon her. Now, he did say in his evidence, and it's open for Your Honor to accept it, that she was relieved, although he didn't quote her. This was his perception of, I think he said his words were, it was in his mother's eyes, that he inferred that she was somehow relieved because of her desire to keep the business in the hands of the family, keep it in the Schmata family. My client's not asking for a piece of the business. My client's not asking to become part of the Schmata business. My client has no Schmata expertise, as was well articulated by Irwin. He wouldn't know shatnez and silk and polyester. But what he does have is an acute need for support. And whether it's the root is by way of setting aside the matrimonial agreement on the basis of the authorities I've cited, or alternatively, as you know, even in the event that there is a valid agreement, the provisions, as I indicated before, of the Succession Law Reform Act and of the Family Law Act permit this court to ignore or take into consideration the existence of the agreement, but what the court has emphasized is what are the circumstances that exist today and not at the time they entered into the agreement. And what we have a situation today, as was clearly articulated by the expert evidence, Ms. Harvey, is a situation where whether or not, and she quite properly answered a question where I think it was Mr. Donovan was challenging the validity of or the propriety of his lifestyle. This is a situation where there's ample authority that the court, it's not the function of the court to indicate to the deceased, get rid of his Lamborghini. Yes, it may sound frivolous to all of us here today that he's still holding on to a Lamborghini, but this was the lifestyle they had become accustomed to for the 5 years of good marriage, to quote Irwin. And it's not for this court to rewrite. In fact, I would submit it would be an error for this court to suggest that the applicant must adjust his lifestyle. He's become accustomed to it. She obviously took rides in it. She enjoyed the 5 years in his Lamborghini, and who he had in his front seat and back seat of the Lamborghini prior to their marriage is completely irrelevant and inflammatory in my respectful view.
So are you saying, this is interesting for me, are you saying that a court must award an amount, that proper support for a dependent is continuation of the lifestyle that they were enjoying before the death of the spouse?
Certainly, I would submit that if the court is satisfied that my client was a dependent and that he's been inadequately provided for, the starting point for discussion, I'm not saying the court is bound to maintain it precisely, but certainly the lifestyle that they've become accustomed to during their marriage, their 5-year marriage, is a an important factor, not determinative, doesn't oust the jurisdiction of the court to make appropriate awards, but what we are seeking is simply based on, and again, this isn't a number that Mr. Schmier has come up with. I think the evidence is that he was irresponsible in his investments, so I wouldn't ask this court to rely on that, but the evidence of our expert witness made clear that this was merely a projection, annual projection, based on anticipated expenses that he would incur in order to maintain that lifestyle.
Thank you, Mr. Rabinowitz. I think your time is up.
Thank you.
Thank you so much.
If it also pleases the court.
We'll see about that.
We shall indeed. I represent, for the purposes of these closing arguments, both Irwin and Zelda, the respondents in this action. And there's been a lot of discussion as to the witnesses and the experts, but what are the 5 issues that are before the court before we get further underway? One is the applicant, Richard, or the Schmier man, as he's lovingly referred to, wishes to set aside the marriage contract or the prenuptial agreement. Second, he seeks dependent support in the amount of $250,000 a year, which the expert has on a lump sum basis indicate has a value of $3.7 million. He seeks a declaration that the inter vivos transfer of the Schmadamart shares from Mum to her children, Irwin and Zelda, on November the 7th was a fraudulent conveyance. He seeks a declaration that the statement made by Yelta, her dying words, on April 3rd, 2015, a full number of months after the actual transfer of the shares to the kids, was a fraudulent conveyance. That was a gift morta causa, sorry. And then lastly, he seeks an extension of the time for him to make an election under the FLA Act for an equalization of net family property. To be clear, it is the respondent's position that this court dismiss all of those claims and with costs going to Irwin and Zelda. So, a lot of facts have been talked about. What do we know? The basic facts that we know, and I'm not going to go through all of them, but we do know this. We know that at the time that he went on the Love Boat in July of 2009, that he was 41 years old. He had just retired from a professional soccer career, football career. He was healthy, no problems with working, no idea that he would have any issues with working in his future. He had lost money, but even with his lifestyle, even with the gambling and bad business deals, he had nearly $1.5 million when he entered that cruise ship, and he had a pension of $80,000. He'd had numerous professional contracts and probably endorsement deals that he entered into. He had dealt with agents and lawyers. He knew exactly what a contract was and what it wasn't. He knew exactly that he'd be bound by a contract when he signed it. So this was of no surprise to him that he entered into these financial circumstances. And when he went on to the boat on July of 2009, he may have been looking for a pot of gold. He may have wanted to increase his riches, but he darn well knew that 3 months later, when he had a shotgun wedding and he signed the contract and he had a lawyer, he knew exactly what he was getting into, and he knew that he wasn't going to have that pot of gold.
Let me interrupt you for a second. So assume that I find that the marriage contract is valid. How do we deal with the issue of dependent support?
In my submission, Your Honor, and I disagree respectfully that will be the conclusion at the end of the entirety of the trial, but just to answer your question, in order for the applicant to obtain dependent support, he has to show that he was a dependent. And yes, Section 57 says that you're a dependent if you're a spouse, but if you go on into that section, the section carries on to say that it's only in circumstances where the person was providing support or had an obligation to provide support prior to.
The case law is quite clear. If you're spouses, though, there's a legal obligation to provide support to one another. So I have no difficulty whatsoever in finding that he's a dependent. The question is going to be whether, to what extent, if that contract is valid, to what extent, A, that I take it into consideration, and B, if I do and I rule that it doesn't completely oust my jurisdiction, what amount should I be awarding him?
Well, first of all, if the domestic contract is valid, sorry, I want to make sure that I cross that bridge first. If it's valid, I say that the fact of the matter is that ends the whole issue with the FLA claim and the possibility of an extension of the election under the FLA claim. The contract is clear.
Fair enough. Fair enough.
Contract is clear that he ousted and he waived any entire right that he had with respect to her estate and to and under the Succession Law Reform Act and the FLA. So I've dealt with the FLA.
Yeah,
okay?
let's leave that aside. Let's deal
with respect to the dependent support claim. If the contract is valid, and we say that it is, then that in and of itself, we say, ousts the requirement for support. I do understand that under Section 62 of the SLRA that there are numerous factors enumerated under that section for the court to consider. One of those are, has there been an agreement? We would rely on the law, Your Honor, that supports the fact that once there's a domestic contract, that that is not only a terminal factor with respect to the consideration of support, but it is fatal to further consideration of that. And if Your Honor goes beyond that and says, okay, well, I'll cross that bridge, but I'm still going to consider it, it should be given the utmost weight in the consideration of what the support should be in looking at the actual calculation.
Fair enough. And how do we deal with Mr. Rabinowitz, or how do you deal with Mr. Rabinowitz's argument that the transfer of the shares to the kids was a fraudulent conveyance?
Okay, so let's look at that.
Yeah.
Let's look at what really happened. On November the 7th, 2013, which is, let's say, 6 months before Mom passes away, what were the circumstances? Mom was capable. She wasn't unduly influenced. No suggestion, not even a proposition that those are factors that are being taken into consideration. So what does she do? She goes and sees a lawyer, and she transfers the shares. And what makes sense here, Your Honor? There is a company that, at that point in time, she is 70 years old. So that company was built up through a marriage with her former husband and the blood, sweat, and tears that they put into that company. What does she want to do with it? She wants to transfer that to keep the lineage going within her own family. She gives it to her kids.
And triggers $2 million of tax at that time.
Yes, and she had, by, we'll say some account anyways, I'm not quite sure if the agreed statement of fact says that she would have had the appropriate accounting advice. But she was looking after that, and from the standpoint of that, Your Honor, you've touched on something that I would have hit on further in my submissions, but that is, they were doing estate planning on that day, and they were doing planning with respect to probate fees. By transferring those shares as well over to the kids at that particular time, not only was she satisfying a legacy issue that she had with wanting to keep the shares in the company, she was also dealing with the pragmatic aspect of the commercial reality of what would have happened after she passed away. And if Your Honor looks at the Court of Appeal case in McNamee, which is in our factum, it touches on the fact that you can have a legitimate commercial purpose with respect to a transfer in that regard as well. And so I would urge Your Honor to take a look at that case. What did she also do on that day? Well, on November 7th, again, with full capacity and not under any suggestion of undue influence, again, she's healthy. She doesn't know she's going to pass away. There's no suggestion of divorce. She does a will. And at the same time she does a will and leaves her own children as the trustees and the beneficiaries of her estate, she has an insurance policy that's in place for Richard of $1 million, which would more than look after his affairs if he was acting in a responsible manner.
I guess that brings me to the point, which is, it's not just Yenta's decision as far as what's adequate provision for Richard's proper support. That ultimately is my decision, right? So I guess the issue is, was she entitled to transfer those shares, knowing that she had an obligation to support her spouse, which is our law, right, Mr. Van Der Zee? So can she do that? I mean, if it was I take your point that there's no Family Law Act election if the contract is valid. But from a dependent support claim point of view, isn't she trying to defeat that?
Your
right?
Honor, sorry, Your Honor, I didn't mean to interrupt. I thought you had
I'm
finished
finished.
there.
Thank you.
The fact of the matter is that that's irrelevant at this point, given the fact scenario of this circumstance, with the greatest amount of respect. And the reason I say that is that Ms. Harvey gave evidence this morning as an expert of this court where she said that the lump sum payment that he is seeking is $3.7 million. With those shares having been transferred at $8 million to the children, there's still $9.2 million in the estate. Mr. Schmier is not seeking to run and control that company. He is not arguing the law of trust. He's not arguing the law of unjust enrichment of some form with respect to that company. I dare say that it's irrelevant for this court at this point in time, given the circumstances of the dependent support claim, taking into consideration my submissions on the domestic contract and the factors to be taken into consideration, to now be looking at whether that transaction, the $8 million, is even relevant, because there's $9.2 million and he's only seeking $3.7.
Let me go to this point then, and I'm putting you on the spot, Mr. Vander Zee, and you can tell me if you don't want to answer this.
I didn't notice that you were, Your Honor.
If Yenta, and I'm not sure these are the facts, but if Yenta had transferred all of her assets to her children, for the purposes that you maintain were her intention, namely estate planning and that kind of thing, would Stone be engaged in that situation on a dependent support claim only?
Well, Your Honor, Stone is a case that deals with consideration under the Fraudulent Conveyances Act and deals with a situation where a spouse is being considered as a creditor of an estate.
Right.
And I believe, if I have it right, that the court in that case said that, yes, a spouse can be a creditor of the estate, but they have to have an existing claim at the time that the conveyance was made. His claim, at the best, and again, I disagree with the ability to bring the claim, I disagree with the veracity of the claim, and I disagree with the quantum. But even having said that, he had no claim to more than $3.7 million of the estate on his best day, given his expert report. And now that those shares of $8 million were transferred, in my submission, the consideration of that part of the case is now irrelevant.
Fair enough.
And I do say that it had merit for all the reasons that I said.
I hear you. Could you just deal with gift mortis causa, if you could just address that, why the shares, I presume you would argue that that was not a valid gift mortis causa.
Indeed, Your Honor. It is, in fact, our case that, and our position that while the proposition and submission has been made by my friend that it was a proper gift mortis causa, at the end of the day, the case law is clear that one of the elements, the key tenets of having that kind of gift, is the ability to deliver. And if the shares were properly transferred to the children back in November 7th, 2013, she didn't own the shares. And I would dare argue that the mere fact that she had possession of the shares doesn't mean she could transfer them to whoever she wanted to. Irwin Schmada talked about the shares being signed over on November the 7th, but the agreed statement of facts does go farther than that, and does say that on that day they signed paperwork with respect to the transfer of those shares. And so from the standpoint of what was done to execute and effect a proper transfer of those shares on that date, there's no disagreement. There's no evidence before this court that that wasn't done properly. So the fact of the matter is, she didn't own them at the time.
I think you at one point raised that it was done for estate planning purposes. If one of the reasons was to avoid probate fees, and she carried them around with her, wouldn't that have been some evidence that really she was doing it as sort of it was held on resulting trust for her, that she was really the beneficial owner, even though legal title had been transferred?
Sorry, Your Honor, but with the greatest amount of respect, there's no evidence to support that. That may be a supposition on Your Honor's part based on the evidence, but with respect to the evidence that was agreed upon and put into the materials, that wasn't part of it. And so I can only say that there has been no claim to beneficial ownership of those shares by Mother at the particular time. And there's likewise no evidence to suggest that the actual transfer that was done on November the 7th wasn't done in a properly commercial manner. And further, on that day, there is a life insurance policy on her life for the amount of $1 million. And so she had turned her mind to making Richard a designated beneficiary. And while I know Your Honor is going to say that my time is limited and I should clean up, but I would say this about quantum. Ms. Harvey said in her expert evidence, well, at least her report indicates, I think it's page 5, that the lump sum payment, when everything is boiled down in terms of the dependent support payments, is $3.6 million. However, she did admit in her cross-examination, Your Honor, that 1.8 of that is suspect, that it's dependent on Your Honor's finding with respect to the age that Richard will be able to work to. And yes, there is leeway between 20 and 30 years, but there isn't leeway for the age that Ms. Harvey chose, up to 82. I believe that was 4 years in excess. And I believe that the evidence was, and if I've misquoted, Your Honor will have it have it back from the reporter, but I believe the evidence was that yes, 1.8 million was potentially in excess. So if we look at that 3.7 calculation and we take away 1.8, we're down to 1.9. He has 1 million. So we're really talking about $900,000 today. Because if he were to take into consideration the expenses that he completely wastes, and yes, there is some degree of credence to what Mr. Rabinowitz said with respect to the expenses that are set out on the expert report. However, $132,000 for gambling, a Lamborghini, shopping at the best places and going on vacations is not, in my submission, what he's entitled to. And this court has that discretion. Mr. Rabinowitz was very careful to suggest that the court is not bound by a simple agreement with the calculation that it's the lifestyle that he had at the time. He darn well knew that the expenses were his and his alone. There is no evidence to suggest in any way whatsoever that Richard, when he stepped off the altar when he got married, thought that he would even be paying for anything other than 50% of the taxi. And they kept all of their property separate. And those are all factors that when you take a look at that $1.9 million amount and you say and one says to themselves, it's actually $1 million because he's got $1 million, so it's $900,000, and he's got an $80,000 pension, that the $80,000 pension is for the gambling, the Lamborghini, and the rent. And the $1 million will suffice for him for the rest of the life with the expenses that one should normally have.
Thank you, Mr. Vanderzee.